The year is 1950 and the Maharaja of Darbhanga, Kameshwar Singh, files a petition in the Patna High Court challenging the Zamindari Abolition Act 1950. Wait a minute, how did we get here? Hello and welcome. My name is Priya Mirza and this podcast is the longest constitution and we talk about the constitution. So this is our 61st episode and it's a good time to take stock and see what lies ahead on our travels together. First off, we have been looking at Article 19, Part 1, the freedom of speech and expression. And the very next clause, Article 19, Part 2, places reasonable restrictions on those very freedoms. And we have looked at two so far, defamation and contempt of court. And with that, we can now dive deeper into another reasonable restriction, and that is in the interest of public order. The second, we are at such a good point to get under the skin of Article 31 of the Constitution, the right to property, the only fundamental right to have been repealed. Whoa! Because we have spent some time looking at land in Delhi and how it transformed from being a space for public use to private use. That land under DDA went from being just land to property. So we are turning the page and heading off into new exciting territories. Public order, property, and let's get started. Our first story today is about Twitter and a Supreme Court advocate. Yeah, the year is 2019, and Sanjay Hegde's profile picture on Twitter is of August Landmesser. So, this was a man who was photographed in 1936 in a Nazi rally in Germany, and the only one who did not salute Hitler. Hail to that. Plus, Hegde retweeted a poem about social injustice. And neither of them actually qualify as hate speech. But Hegde's account was arbitrarily suspended by Twitter. So you remember when Prashant Bhushan tweeted about the Chief Justice of India? The charge of contempt of court was made against Bhushan and Twitter. But before the court gave directions, Twitter quickly pulled down Bhushan's tweets. But in Hegde's case, Twitter permanently suspended his account. And the questions are, what are the constitutional obligations for a private party? Like Facebook, Twitter, Instagram. We live our lives on the internet. So are large multinational corporations, these intermediaries which are discharging a public function by serving millions of users, and by the way, making profit out of them, are these open to constitutional scrutiny for their actions? Because although they help us realize our freedom of speech, impact our privacy, and hold great power, they can be opaque, secretive, and arbitrary. In 2019, Hegde petitioned the government challenging Twitter's actions as being unconstitutional. Okay now, what was that Maharaja of Darbhanga up to? And property. What did the right to property actually mean? And that is Article 31 of the Constitution. So interestingly, since as a historian, my research work is on colonial India, which means a lot of delicious time reading old dusty files at various archives, I've come across many records about this guy. And this Maharaja wasn't really a Maharaja at all. He spent a lot of his time writing long, weepy letters to the British colonial government, begging to be anointed as Maharaja. And each time they would say, nope, your blood ain't blue. You're just a landlord, a zamindar. And zamindars have zameen. But the new Congress government, with its ideas of justice and social equality, wanted to abolish it because gigantic parcels of land were owned by zamindars with long torturous histories of labor exploitation. So, three things about the right to property. It's the only fundamental right to have been abolished in 1978. It was the second most contentious provision in the drafting of our constitution and the most amended provision. Oof, what was happening? By the way, what do you think was the most contentious and hotly debated provision of the Constituent Assembly? The right to life? Religious minorities? Well, be patient, you will be surprised. Back to property. And let's ask a question which Govind Ballabh Pant asked in the Constituent Assembly when this was being debated. What if the state acquired Connaught Place and pulled down all those shops because the state decided that it would use that land for the public purpose of providing homes for government employees. Now, this question of CP is actually very close to the bone, my bones at least, because Connaught Place is very close to where I work. And one of the nicest things is to finish a day's work and go hang out in CP. Plus, it's one of the few places in Delhi which actually has a pavement. Okay, but on a serious note, are there limits to the state's acquisition of property? And that was Pun's question. And that is exactly how one analyzes the right to property, which is rather than seeing it as the individual's right to property, it needs to be seen as what the state cannot do. As ultimately adopted, Article 19, Part 1, Part F of the Constitution guaranteed to all citizens the fundamental right to acquire, hold, and dispose of property, plus Article 31, no person shall be deprived of his property save by authority of law. Now, this is a fairly lengthy article, and not to worry, we will be poring over every detail. So, in short, Article 31 is about the limits of state control over property. And therefore, finally, the Constituent Assembly decided property could be acquired for public use only on the payment of just compensation. Except the Maharaja of Darbhanga claimed that his zameen, which was being acquired by the government, served no public purpose, did not adequately compensate him, and claimed that this violated his right to equality under Article 14. Our third story today is to do with Modi, Ramji Lal Modi. So the year is 1952, and Modi publishes an article in Gau Rakshak about cow protection. And this appears to be an article which intentionally outraged Muslims. Modi was charged with Section 295A of the Indian Penal Code, which made the malicious insulting of a religion unlawful, and going by Article 19, Part 2, was to be restricted as it affected the interests of public order. Now, the point to note here is that this was an article with minimal, visible, and violent repercussions. There were no riots, murders, outwardly very little effect on public order. So Modi challenged the constitutionality of Section 295A itself. He argued that this would be valid only if the speech was actually going to create public disorder, with its connection to the disorder being proximate. Meanwhile, in Sanjay Hegde versus Ministry of Electronics and Information Technology 2019, Hegde's petition was that online speech could not be arbitrarily censored by Twitter. And what did Twitter have to say about this? Hear this out. Twitter argued that it was not obliged to adhere to India's constitutional mandates. In Kameshwar Singh versus State of Bihar 1951, the Patna High Court invalidated the Bihar Zamindari abolition law for violating Kameshwar Singh's right to equality. What? Was that a victory for this zamindar? And what would the Bihar government do if the Patna High Court struck down a law? Meanwhile, in Ramji Lal Modi versus State of UP 1957, Modi was convicted. Why does that sound so nice? The court said that the phrase, in the interests of public order, covered all cases where the act in question had a tendency to cause public disorder, without the disorder actually occurring. So today's takeaways are: the first obstacle in Nehru's government to bring in social equality were landowners, whose lands were being acquired by the government. And would this revolution be stalled by the judiciary? The Hegde case highlighted the absence of laws in regulating intermediaries, which play a powerful role in making the public online sphere and marketplace of ideas. And when it comes to public order, the court felt in the Modi case that it does not matter whether there is actual violence. Merely saying or writing is enough for prosecution. That's all for today, gentle listeners. If you have questions or comments, please send them in via email. That's thelongestconstitution@gmail.com. You can also rate my podcast at Spotify and drop a review at Apple Podcasts, and can also reach out to me on Twitter, where I am at FundamentallyP, or on Instagram, The Longest Constitution. Until next time, this is me, Priya Mirza, signing out.